We'll go ahead and get started. Welcome, everyone. Thank you for joining us tonight. My name is Alex Schumann. I am the Stewardship Director at Aquidneck Land Trust. And of course, you're in a workshop on Citizen and Planning and Land Use Planning 101. This is being presented by Aquidneck Land Trust in partnership with GrowSmart Rhode Island, who you'll hear from in a moment. And it's part of a series of 4 workshops this summer and fall. The first was focused in Middletown in July. The second is, of course, tonight, geared more towards Newport. The third is in the end of September for Portsmouth. And those 3 are more or less the same content, just tweaked a little bit for each of the communities. And the fourth will be sort of a more advanced course on land use planning, and that is October 20th. And we wanted to say thank you so much to the Van Buren Charitable Foundation, who has funded this series of workshops. So thank you to them for making this happen and for everything they do for the island. Before I hand it over to John Flaherty at GrowSmart, I just wanted to take a moment to give a little bit of background on the genesis of these workshops. So in 2019, the Aquidneck Land Trust worked with Suzaki Associates, which is a planning firm out of Boston, to look at the future of development on Aquidneck Island. And I'll share a little bit on that report in a few moments. But one of the things that came out of that was a big community workshop where we had around 100, 125 folks attend, where we shared the results and got community feedback. And one of the things we found were folks were just really, really passionate about the future of the island and development on the island. And it ranged from, folks concerned about, the farm in their neighborhood being developed into a subdivision, losing scenic viewscapes, but it also touched on concerns about the impact of Airbnb in the community, or how new development might cause gentrification in the neighborhood. So a lot of different themes came up. And one of the things that also really was evident is folks really wanted to participate. They were passionate, but it was they were unclear how to do so and what the process was when a development comes forward, how a comprehensive plan works, what the decision-making process is. So these workshops stemmed from that. We were able to work with GrowSmart to put them on. And the idea here is just to provide information. It's not to share a certain viewpoint. It's just, we want folks to be sort of educated and feel comfortable participating in these processes in their community. So that's the goal of the workshop tonight. So with that, I'll hand it over to John.
Thanks, Alex. Hello, everyone. My name is John Flaherty, and I'm the Deputy Director at GrowSmart Rhode Island. I'm very pleased to welcome you to this second installment in a series of 4 Citizen Planning 101 workshops. So at this time, when many of us are taking stock of the future well-being of our communities, GrowSmart is very excited to be partnering with the Aquidneck Land Trust on this particular series. It's focusing on how all of you can ensure the future environmental and economic well-being of this outstanding place, Aquidneck Island. In a few minutes, you'll be hearing from Alex once again, ALT's expert stewardship director. He'll address the more specific challenges and opportunities that Aquidneck Island faces in achieving both expanded economic opportunity as well as housing opportunity, while simultaneously protecting the island's beautiful, pristine landscapes. So in addition to setting the stage for tonight's workshop, I wanted to introduce you a little bit to GrowSmart Rhode Island for those that might not know about GrowSmart. We are a nonprofit policy research, advocacy, and land use training organization, and we're committed to making Rhode Island a place where every person benefits from vibrant neighborhoods and downtowns, restored and protected natural resources, and a just and resilient economy. One of the major ways we pursue these critical goals is through our community land use training program, which has been around for most of GrowSmart's 23 years. The program has relied on exceptional volunteer-led volunteer land use professionals to deliver its workshops. And tonight's latest example of that, thanks to the duo of Ashley Sweet and Caroline Wells. And I'm going to say a little bit more about Ashley and Caroline shortly. Another thing about the land use training program is it's got 2 major components to it. One is much more basic training for local elected and appointed officials in managing their land use decision-making responsibilities as effectively as possible. The other component is specialized training for these folks, as well as for concerned community residents on specific smart growth tools to encourage well-planned pedestrian and transit-friendly development in built-up areas, while also conserving our natural key resources. Before Ashley and Caroline do their thing, which will involve walking you through the fundamentals of Newport's land use decision-making process and how you can influence it, you'll hear a summary from Alex shortly about the key takeaways from the report that he just spoke about a few moments ago. After Alex's remarks, Ashley and Ashley and Caroline's presentation, there'll be about a 20-minute opportunity to pose questions from what you hear from both Caroline and Ashley. And we encourage you to use the chat feature to do that, just the opposite. We encourage you to use the Q&A feature, not the chat. And then we'll be adjourning at about 6:30 p.m. As you know, because you heard it at the very beginning, the session is being recorded, and we'll make that available within 1 or 2 days after the event. Now it's my pleasure to turn it back over to Alex, the Stewardship Director of the ALT. Alex.
Thanks, John. I'm just going to share my screen here. Is that up? Great, thanks. So as John said, I'm just going to take 10 minutes to kick off here to share kind of a bird's eye, higher level summary of the development impact analysis we did a few years ago. And this was done in partnership with Suzaki Associates. And the full report is available on our website. It goes into fairly extensive detail about the results, lots of great maps, and really transparent methods. So I encourage folks, if you're interested in really a deep dive, to check it out, and I'll share the link to that at the end of the presentation. So the goal of the analysis was to understand the potential impacts of future development on Aquidneck Island, so looking at all 3 towns on the island. And we did that looking at 2 different scenarios. So one was looking at the status quo. Basically, if we have our existing conditions, what might the island look like by 2050? And then the second was looking at a different path, one where we kind of prioritize conservation of open space and still accommodated for the same level of development and housing needed, but we redirected that development in a different way, made more compact, smart growth friendly development patterns. And we called these scenario 1 and scenario 2. So I'll be referring to those for the next few minutes. The way this analysis worked is we had all the parcels on Aquidneck Island. We put together a model on how the development pattern might unfold under each of these scenarios over 30 years. Once we had the model put together and the data, we visualized it out over a series of maps and renderings. When we had the results, we then looked at, all right, how will that development pattern being built out, how will that impact our way of life on Aquidneck Island, from natural resources to the local economy and tax revenue. And then, of course, we sort of try to tease out different themes and things we found to make some key findings. So one of the interesting things about the development pattern on the island is we have a basically flat population that hasn't grown much. In fact, it's declined a little since 1980 at around 60,000 residents on the island. As you can see on the map here. But even despite that, we've had 6,200 new units built since 1980, or a rate at about 165 per year. And the reason for that is probably a few different reasons. The primary one is just we have a really robust second home market here on Aquidneck Island. Lots of people are still building vacation homes and second homes, even though they're not necessarily living here full time. The second might be just sort of the Airbnb phenomenon, which is taking housing stock out of sort of year-long residents. And then the third is the last few decades, household size has decreased. So in order to accommodate the same number of people, you sort of need more housing in that case. So it's probably a combination of those 3 factors. But the 165 unit piece is really important for our analysis because it established kind of the development demand per year looking forward into the future. Of course, that may be conservative if there's more demand in the coming years. So one of the first things we did was get together existing conditions, and we put together a really comprehensive land use map for the island. Some of the interesting findings, around 50% of the open space on Aquidneck Island is unrestricted to development, so it could be built on. And of that unrestricted open space, around 80% is zoned residential. So that's most of the development pressure we're facing based on existing zoning, and most of that existing zoning is medium and sort of low density residential. And this is, if you know your aerials, this is looking up north on West Main Road, sort of on the Middletown Newport border. There's the Potter Leaf right there. So in scenario one, we sort of looked at how all the parcels on the island with current zoning, what they would support. Again, looking at that 165 unit per year across the 3 towns. And this is sort of what we saw. You can see the red houses here. These are all new kind of subdivision houses allowed under zoning, roughly. And what we saw, this is sort of a showing Middletown and Portsmouth, but farmland, the larger tracts in Middletown and Portsmouth, most of them converted sort of to this style of housing as allowed under zoning. And when you look at, so that was scenario one, which is status quo again. Scenario two, which focused on conservation, a lot more land was protected, but the same amount of growth, we still accommodated the same amount of development. And that's because if you look at the difference here between the two, scenario two sort of allowed certain areas to be a little more densely built than the current zoning. So you have a larger mixed use development here rendered out. This little residential area is a little denser, but as a result of that, you have a lot more space that you can save for conservation. And here's an example, not meant to be parcel specific, but just to show kind of what we're talking about when we talk about kind of redeveloping into mixed use. Here's sort of an old fashioned strip mall, kind of very parking centric, not very walkable. You know, in scenario two, we look at converting some of those areas into more of a mixed use town center type style development that accommodates both residential and commercial use and is more walkable. Easier place to, you know, walk around, go to a shop, live there as well. And so when you look at the maps here, I think this is quite striking. And this is scenario one for Aquidneck Island. The red are all areas that are built on and developed and status quo by 2050. And scenario two, again, accommodating the same amount of growth. You can see much less of the land is being used for development. And we found that actually in the status quo, we would lose 3,000 acres on the island of open space versus 900 acres lost in the plan and protect scenario. And the difference of 2,100 acres is quite a bit for Aquidneck Island. It's almost 10% of the land. So I think one of the interesting things about our analysis was, I think right now, we're all feeling sort of a housing shortage on the island, both for affordable housing, but also just workforce housing sort of for middle class folks. And what we've shown in this analysis is that we can still accommodate that need for housing while still saving a lot of land if we just do it in a smart way. So when we had all those results put together, we looked at a number of different impacts. I'm just going to highlight a few. So if you're in Newport and you're thinking to yourself, why do I care what's going on in Middletown and Portsmouth? I never go over there. I don't care if, you know, some subdivisions get built on farmland there. One of the reasons you should care is because all of our drinking water is basically coming from those 2 towns. The water reservoirs that service the Newport water supply, 7 of them are in the 2 towns, another 2 are across the Sakonnet River. So the land use in those watersheds is really important for the quality of the source water and of course, you know, treatment costs and that sort of thing. So we looked at the difference in the 2 scenarios and of course found that with the higher density of the higher scenario 1, the status quo, we saw more pollutants, more impervious surface in those watersheds. The other piece we looked at was just the threat to the agricultural heritage and farmland on the island. Of course, we don't have much farmland in Newport, but again, if you like going to the farmer's market, if you like the farm to table movement at Newport restaurants, they're of course linked, right? A lot of our farms servicing those are in Middletown and Portsmouth. And when you think about climate change, of course, having some land saved for farmland, if systems become more local, if it's harder to grow out west, this will be important. So in scenario 1, we lost around 3/4 of the unrestricted farmland. In scenario 2, we only lost around 22%. And then, of course, a big one is tax revenue. So one of the compelling cases, I think, for more mixed use as well is that it provides much higher value per acre in terms of tax revenue. So we saw between the two scenarios, sort of the smart growth focused approach showed around an 8.4% increase in island-wide tax revenue moving forward. So that was a big difference there as well. And if you think about it, it makes sense, right? Because you have a mix of commercial and residence in, let's say an acre space, maybe in a suburban area that can only fit 2 houses. So the tax revenue is much different in those cases. So we looked at a lot of different impacts. Those are all in the report. I just wanted to highlight a few there. And then before I hand it back over to the panelists, just some of the key findings from our report is if the status quo continues, and of course, the development, if something we've seen the last couple of years is there's a huge demand for development. If that continues, this will probably occur in a much shorter time period. But by 2050, we projected that we would run out of unprotected open space. So land would either be conserved or it would be gone. And of course, that's going to impact a lot of our natural resources here on the island. We also took away that current development trends can be really harmful to the natural resources that are important here and provide ecosystem services here on the island, and also provide lower per acre tax-based revenue. And one of the things about being on Aquidneck Island, I think, is the need for regional planning. We all use the transportation network here in all 3 towns. We all share the same drinking water, more or less. A lot of the resources are spread out across the 3 towns. So regional planning is certainly important moving forward as well. So that's a little, just a short sort of bird's eye level of the analysis. Feel free to reach out with questions. The whole thing's on our website as well. And I'll share the link. Oops.
Okay, so thank you, Alex. Those last couple of slides that we saw just before Alex brought the screen down was a good reminder for me to let you know that there is a survey that you'll see after you close your screen out this evening. We hope you take the opportunity to give us some feedback. And at this time, I wanted to say thank you once again to our expert presenters this evening, Ashley Sweet and Caroline Wells. And I wanted to provide a little bit of background about Ashley and Caroline, starting with Ashley. Currently, she is a project manager at the environmental and engineering firm, Weston & Sampson. Her 20-year planning career has included stints as the town planner in Exeter, Charlestown, and Hopkinton. And she is currently the president of the Rhode Island chapter of the American Planning Association. Ashley has a master's in community planning from the University of Rhode Island, and an undergrad degree from URI in marine and coastal policy management. As a planning and land use consultant, Ashley has represented both developers and citizens groups regarding proposed development applications, serving as an intermediary on their behalf. She's been a longtime advisor and trainer for GrowSmart Rhode Island, and we're very appreciative of that. I'm turning now to Caroline. Caroline Wells, another longtime advisor and trainer for GrowSmart Rhode Island. Caroline has numerous other credentials and accomplishments, including 20 years of professional experience in the fields of urban and transportation planning, redevelopment, housing, and preservation. She's worked for several different organizations, including the town of Warren. She's trained and experienced in community outreach and engagement, which is a great thing for this evening, and has worked closely with diverse residents, neighborhoods, nonprofit organizations, and government entities on a variety of district and municipal plans. She and her planning initiatives have won several awards, including one from GrowSmart Rhode Island, citing the town of Warren's numerous smart growth innovations during Caroline's tenure as the town planner. So at this point, I'm going to turn it over to Ashley and Caroline, and the floor is yours.
Thank you. All right, so Ashley's going to run the slides, and I'll talk first for part one. Ashley will pick up for part two, and then we'll all talk together at part three. So just to introduce our content, Ashley, could you roll it forward, please?
Yes.
So you've heard a little bit about us. Our goals for this workshop are that you come away with an understanding of land use planning generally, how the different planning documents can fit together, how you can make your voice heard in the planning process. And we will talk a little bit more at the end about, other training opportunities and where you can take that knowledge going forward. Next slide, please. I'm not going to read all of this, but the Land Use Training Collaborative, as been discussed, is an ongoing process to bring knowledge to people, particularly people who work in our local decision-making capacities. Next slide. So the curriculum is several modules involved in this. This is the most rudimentary one. So we're going to get you started understanding the basics about land use planning. If you want to continue, you can take more specialized modules and sort of refine your knowledge. Next slide.
Caroline, I don't want to interrupt you, but are you seeing the right screen?
I'm seeing Citizen Planning 101 curriculum.
Are you seeing it with a black background or just the slide?
Just the slide.
Okay, just checking.
Okay. And so workshop goals, like I said, we're going to talk about the land use decision-making process in the local community, how you can get involved, how local decisions are made, getting a little bit more familiar with some of the terminology that we use, and we use a lot of really specialized terminology. We try not to, but we do. And also to boost the confidence of regular public participants and their rights as citizens to engage in the planning process. Next slide. Same thing. Next slide. I don't know why we have so many repetitive slides. Okay, now we're getting to the meat and potatoes of it. What is land use planning? Land use planning in the big picture, in the idealistic picture, is how we arrange communities to meet our needs. I would say it's not always that. In fact, it often isn't that. Often we have needs that are not being addressed in the land use process, or we have other factors that are playing into the land use process, like local politics or other values. So land use planning, like anything in the public realm, requires an active citizenry to make sure that the shared values of the community make it into land use planning. So land use planning is a process, but it's also the result of that process, the set of policies that guide how our communities are developed. It's also the mechanism of how we envision our future and how we get there. So it's iterative. We're never done planning. We're always getting to the next stage, and then we're thinking about what's next. So to that end, it's a tool. It's a regulatory mechanism. It's an envisioning process. So it's all of these things together. But the point of it is that it's supposed to reflect the community's values and the community's needs. Next slide. So here's how the general process works. There's up on the upper left around 10 o'clock is the start here arrow. When we go through a land use planning process, if we're going from scratch, which we often aren't, but let's just say we are, what we do is we gather all of the data that might be necessary, anything that we can find related to the land use planning issue or the community as a whole. We look through potential challenges, we meet and make sure that we have all of the financial documents, all of the trends, census data, everything that we can gather. From that, we start thinking, okay, where are the gaps in this situation? What's missing? Are we missing housing? Are we missing affordable housing? Are we missing recreational facilities? Are we missing budget and operational issues that we're not maintaining our public infrastructure? Those are the things that we're going to think about in that planning process. And from there, we develop our long range goals. Where do we want to see the planning process in 20 years, 10 years? What's our time horizon? And usually in that process, we create a vision. Sometimes it seems a little hokey, but the idea is that when you create a vision, you're putting on paper what your value system is that you're operating under. And that is often a shared conversation, a collective decision. From there, you start creating your more detailed plan. You take your vision, you take your existing conditions that you've found out through your data gathering, and you start putting them together. And also, which is not totally woven in here, throughout this process, you should be, if it's a good planning process, engaging the community. You should be engaging the community on the front end, the visioning. You should be asking the community what are their thoughts on certain specific issues, such as land use, recreation, housing, economic development. So all of this feedback that we gather, we synthesize together into a more detailed plan. That plan will express goals under each particular topic, housing, economic development, and such. And under those goals, we'll usually have, sometimes they'll say strategies and actions, but there's always actions. What are the actions that you are going to make as a town to achieve your goals? And in turn, how are all those goals going to achieve your vision? So that in its total is the plan. A good planning process, and there aren't enough of them, goes back and evaluates. It accounts for what the community was able to achieve. So ideally, your community has its planning documents front and center, and people know it. And every year, every 5 years, somebody's going, okay, of our planning actions, what did we achieve? Are we doing this? And if we didn't achieve something, why didn't we? Next slide. The mother of all plans is the comprehensive plan at the local level. The comprehensive plan is a core document that encapsulates all of the community's vision and goals. So it is the guiding document that all of your zoning and your other regulations should fall behind and like effectuate, I guess is the word, if that is a word. Realize is the word I'm looking for. So whether you're doing redevelopment or housing plans, each one of those should be tied to your comprehensive plan. And in Massachusetts, that's a master plan. So it's called different things in different states. Rhode Island is a comprehensive plan. Next slide. There's a lot of words on this page, but what it means is, why is the comp plan important? Well, it's that rational basis for development. It's the thing that tells us how we want our development to happen in our cities and towns. Ideally, it helps us avoid conflict, or it gives us a basis from which to engage and react to development that we feel is out of step with our local visions. It provides a basis of technical information so we can all be on the same page and know that we're talking from the same data points. And it talks about the appropriate uses of land as it pertains to our shared vision. You want to say appropriate for whom, but we should have already decided that in writing our comp plan, what we mean by appropriate. It is also the basis for municipal initiatives. So the city or town can operate from its comprehensive plan. The comprehensive plan will often say, you need to study this more. You need to design for that more. So that gives the town its steps forward to realize the plan. It also ensures, theoretically, access, equitable access through housing choices. Is your comprehensive plan reflecting everybody in the community, regardless of race, of age, of gender, whatever, ability? It also recognizes the potential for conflicts in land uses. They happen, and sometimes we don't realize them until they come before the planning board. Like, wow, how did this happen? But the comprehensive plan is important because it gives us that the sort of conscience of the community to judge some of these new cases. Ideally, it helps us coordinate, and it helps us be more uniform in our conversation about development and more consistent in how we talk about development within the municipality. Next slide. The real backbone of land use planning is the zoning ordinance. The zoning ordinance, I always say, like, the zoning ordinance is really more of a black and white regulatory scheme. We always say it's a police power. We enforce zoning. Whereas planning is a little bit more aspirational. Zoning is, you either are in compliance or you're not. So a zoning ordinance divides the municipality into districts, as you know, and each district has a use. And that use is defined, or a set of uses are defined. Their buildings in that particular district have to meet certain dimensional requirements. They have to meet certain performance and design requirements. And it also sets forth, the zoning ordinance sets forth the conditions in which people may vary from that. We call them variances. People apply for variances. They say, I can't meet this standard, and this is why. And there's legal a basis for these things. You can't just say anything, and zoning boards are obligated to follow the law as they administer the zoning ordinance. But just so you're aware, it's pretty much cut and dry when you're writing a zoning ordinance. There's nothing fuzzy about it. Why is it important? Because it is the regulatory mechanism for growth and development. Ideally, it protects resources. Ideally, it protects public health and safety. When done well, it can really elevate design. It can really conserve and preserve quality of life and smart growth kind of values. And it can also really solidify the goals of the comprehensive plan. By changing zoning, you can change a lot about how development happens at the local level. Next slide. So by contrast, there's the land development and subdivision regulations. That is often much more at the parcel level. It's not about districts at this point. It's about how a particular parcel or group of land parcels will be developed. It's much more fine-grained. And so it also establishes how it'll be reviewed. So the community could establish what's called a technical review committee. That's a very valuable resource where somebody who wants to develop a land parcel can meet with a technical review committee. It's very informal, and that's the point of it. Everybody is kind of off the record, and they can say honestly to a developer, this is going to work for us, this is not going to work for us. And there's ways of creating a better development before it gets to the planning board. The subdivision regs also really focus on physical design requirements. So for example, if you're looking at climate resiliency, which Ashley and I are both working on right now, you can often land some of those techniques in the subdivision regulations, things like nature-based improvements to control stormwater and flooding. That's where that happens. That often happens at the subdivision regulation level. It also can talk about public design and improvement standards. So this is sort of where we get some unity in the way our streets and sidewalks, lighting and landscaping, all of the standards that are built in the subdivision regs per lot get applied. But then when you step back in the neighborhood as a whole looks uniform. Next slide, please. There are also more specialized ordinances, and that could be either in the zoning ordinance, usually it's in the zoning ordinance, and that will talk about historic districts. It could be conservation. You could have overlay districts, which are zoning districts that kind of float over other districts. So you might have a residential district, but it also has a conservation district or a water management district on top of it. And what happens is both regulations apply to that particular physical area. And they can meet all different types of goals, whether they be, urban shade trees or historic preservation standards or anything the community desires. That's where it lands. Usually is in these specialized ordinances. Next slide, please. Yeah, I just talked about the overlay district. It is, as I said, a regulatory tool. And what I forgot to say is that you can also attach incentives to it. So if a developer is locating, for example, in a downtown district, you can often incentivize that. For example, if you want artists in your downtown district, you might tie certain incentives for either permitting or some sort of tax reductions, that sort of thing. You can incentivize as well as restrict. Next slide. So that's my part one. We covered what is land use planning and how do we plan for land uses. We talked about some of the tools that we use, like the zoning ordinances and the subdivision regulations. Okay.
I'm going to talk to you guys a little bit about the decision-making process and who makes those decisions and what their roles are that they should be playing. So there's 3 governing bodies that are going to be involved in land use decision-making. At the city council, town or city council level, they're responsible ultimately for approving the comprehensive plan and the zoning ordinance. They would approve any amendments to a zoning ordinance, which would include overlay districts or any master plans. And they're also going to hear recommendations from the planning and zoning boards on these types of decisions. So for instance, in a situation of a zoning amendment, the planning board's required to provide an advisory opinion to the town council prior to the town council ultimately making that decision at a public hearing. The role that a planning board or planning commission will play is they're responsible for enacting the land development and subdivision regulations. They're also responsible solely for drafting and approving those regulations. It's the only document involved in land use that doesn't go to the town council for approval. The planning board has the sole authority to amend and approve their own regulations. They also are going to review site plans for permitted uses, and they approve and deny applications for subdivisions and land development projects through a multi-step process that's laid out in state law. They're the body that typically will draft zoning ordinances as well, although they don't have authority to approve. They are the body in coordination with the town's planning department that would be drafting zoning amendments and then sending those to the town council for consideration at a public hearing. The planning board is also responsible for updates to the comprehensive plan. They're the authors of those documents, which then get again sent to the town council for ultimate approval at that level. And as I had mentioned, they can initiate and review proposed amendments to the zoning ordinance. The zoning board operates slightly differently. They are really the body that grants relief from the zoning ordinance. That is that's their function, in whether it's in the form of a variance or a special use permit. They do hear appeals from decisions by the zoning enforcement officer, and they sit as the zoning board of review and will hear appeals from decisions by the planning board. So if an applicant appeals a planning board decision, that appeal sits before the zoning board, and they sit as the review body for that. They do not actually enforce the zoning ordinance. That's the role of the zoning enforcement officer or the zoning official. But they, again, as I said, they are the body that essentially grants relief from the zoning ordinance. And then there are historic districts. Historic district commissions oversee a certain area of the community that's been designated and has enabling legislation under state law to make land use decisions for that historic district. And they create special zoning, which is intended to essentially preserve the area as it is, whether it's architecture or character or a sense of community. So the city or town council would pass that ordinance, and they would have to establish a historic district, which then is in charge of enforcing those regulations and making decisions within the district. So I know Newport has a historic district commission. It has a historic district. I'm not going to read all of this for you, but essentially the concept being that that historic district has that authority over a certain area of Newport where the district is designated. And these are typically architectural features, design guidelines for exterior changes. If you're asking to make changes to your property within the historic district, you apply for a certificate of appropriateness from that historic district. And there are some things that are not included, as you can see here, paint color and landscaping and temporary decorations, but any kind of major renovations or changes to the structure would be captured by that historic district and would require an appearance before the district for permission. This is a flow chart to give you an idea of how things kind of flow in land use. The council appoints these boards and commissions, so planning board members and zoning board members are appointed by the town council. With the exception of Charlestown is the only elected planning board in the state. The council, the zoning board and the commission make recommendations to the council on certain issues, specifically zoning amendments and comprehensive plan amendments. And the planning board is in charge of those subdivision regulations. And as Caroline described, those are down at the parcel level. That's kind of on the micro level, looking at how individual parcels are developed. And on the flip side of that, the planning board is also responsible for the bigger picture comprehensive plan that kind of sets that policy guidance for the entire town. And in there, the zoning board is making decisions on relief from the zoning ordinance. So anytime an applicant cannot meet the standards of the zoning ordinance, they have an opportunity to apply to the zoning board to be granted relief. So there's a review process, as I mentioned, and first we're going to take a look at the standards for zoning. So all of this is enabled in state law, and the zoning board is required to look at a dimensional variance. A dimensional variance is anytime an applicant can't meet the dimensional requirements, whether that be a height of a building, a setback of a building, the lot coverage of a structure. Those are all dimensional relief situations where the zoning board needs to take a look at certain standards and to be able to make a positive finding to grant that relief. So they have to look at the unique character of the property or structure, that it can't be due to the general characteristics of the area. The sole purpose cannot be for an economic advantage or economic disability. The hardship can't be created by something that they did previously. If they previously, created a situation and now they're asking to make it worse, that would disqualify them from being able to do that. They need to be able to say positively that it's not going to alter the general character of the area, that it doesn't, impair the intent of the overall zoning ordinance. It's the least relief necessary, and that the hardship is more than a mere inconvenience. And the zoning board is allowed to attach special conditions to those grantings of relief that they feel are appropriate, that will allow them to say that the application meets these general standards. For a special use permit, it's a similar situation, or that it's enabled under state law. I'm not going to go through all of these. Some of them are very similar. But one thing with a special use permit is that the difference being is that the use is what's not allowed, as opposed to the dimensional standards that are being given relief from. So in a case where the zoning ordinance identifies a particular type of use and it's not a use that's allowed by right, it's a use that's allowed by special use permit, and that is where the applicant has to come in and demonstrate that they will meet all of these standards. And unless they can demonstrate that and the zoning board can find positively, then that use is considered not allowed in the district. So you have to make application for those types of uses. And those are typically reserved for uses that could be questionable in terms of how they're going to impact the surrounding area. If it's high traffic, if it's a noisy facility, if it produces some kind of impact to the neighborhood, potentially produces an impact, those uses are typically given a special use designation. And so that's when you have to come in and the applicant has to present information to the zoning board to show that they can meet all of the requirements. So the planning board has a bit of a different role and a bit of a different process that they have to go to. They are required to find consistency with the comprehensive plan in any of their decision making, consistency with the zoning ordinance. They have to show that there are no significant environmental impacts. They're not allowed to create lots in a subdivision process that would make building impracticable, or that lots that don't have access to a public street. And communities are allowed to add to these required findings. These are the required findings that you'll find in the enabling legislation, but many communities have gone somewhat beyond that and placed additional required findings. So in the process of the planning board receiving an application and going through all of the documents that have been provided and all of the testimony, these are the findings that they have to keep in mind as they're going through this, knowing at the end of the process, they have to be able to find positively on these in order to approve an application for subdivision. So there are a couple of different types of land development projects. There's conservation developments, which are essentially residential subdivisions that rearrange the location of homes, keeping the density the same, and they're designing around the physical characteristics of the land, as opposed to cookie cutter subdivisioning, at a minimum lot size. They are reconfiguring where those homes are placed. You can see the two pictures on the left, the top being the standard subdivision where the entire property is cut up into uniform size lots. The picture on the lower being clustering those homes around a central roadway and preserving large portions of open space. Residential compounds are a trade-off between the applicant and the community. Typically, they are at a lower density than is allowed by the underlying zoning, and there's fewer infrastructure improvements required by the applicant. They may get the ability to put in a dirt road as opposed to being required to have a pavement, which is a cost savings for them. The trade-off for the town being that they get less house lots in the subdivision. And then land development projects have multiple buildings on one site, and they can be a mix of both residential and non-residential uses. And there are two types of subdivisions. There's major subdivisions and minor subdivisions. Major subdivisions are required to have 4 stages of review. A pre-application conference is a very informal meeting with the planning board. It's an exchange of ideas. There's no decision making at this level. The planning board is not making decisions. They're simply providing feedback to the applicant so they can take that feedback and apply it to their application and come back at a master plan stage, which is a conceptual design, but it has got some engineering behind it that gives the planning board the ability to respond to that engineering. Once you get past the master plan stage, the preliminary plan is a fully engineered plan that has received all of its required state permits, and it undergoes a detailed review. There's a public hearing that's required at this stage with notice to abutters, and the planning board can place conditions on the application at this stage of review. They can also place conditions on it at a master plan stage, but again, that is considered a conceptual stage. And then there's a final stage where the planner or the planning board can grant final approval, depending on the complexity of the application. The planning board does have the ability to grant administrative approval authority to the town planner to finish that application. And then we have minor subdivisions. Minor subdivisions typically consist of 3 stages of review, and it's 5 or fewer. I forgot to mention that. A master plan is 6, a major subdivision is 6 lots or more. A minor subdivision is 5 or fewer lots. And there is a pre-application conference, which at the minor stage is not reviewed, it's not required, but it's definitely recommended. It gives the opportunity for that exchange of information for the applicant and the planning board to go back and forth and exchange ideas and to give kind of initial feelings on what's being proposed. The second stage being preliminary plan, where the applicant submits fully engineered plans. And the final stage, again, being either before the planning board or the planner, depending on the complexity of the application, and they grant final approval, making sure that all the conditions from preliminary plan have been satisfied. And so in making a decision, the planning board has to look at whether or not the plans comply with the regulations and meet the standards. The decisions cannot be based on their own opinions. They can't just dislike something and decide to not approve an application because of that. If the applicant's land is zoned for the proposed use and the plans meet the requirement for the development, the planning board has little wiggle room there to be able to deny an application. There has to be some kind of outstanding issue or something where they don't meet the standards, or they haven't proven to the planning board satisfactorily that they do meet the standards in order for them to be able to deny an application. So this is probably really small on your screen. It's very small on mine and hard to see. But this is, again, another type of flow chart that gives you an idea of the public body's responsibilities. And there are you'll see there's little time clocks in there. Those clocks represent a stage of review where there is a clock that starts ticking. And so planning boards are held to timeframes in their decision-making. And when you initiate an application, there is a requirement that it be certified complete by the town planner or administrative officer, and that initiates a time clock. And then the planning board only has a certain amount of time, depending on the stage of review and the type of application, in order to make those decisions. So they are held to a time frame to do their work. So this is about demolition permits. I don't know much about Newport and their demolition permits, but I'll read through this slide with you. So there are structures that are associated with the principal use of a property, and those require demolition permits. And there has to be a finding that there's no detriment to the public health, that it is consistent with the comprehensive plan. It does not create land with constraints, and that it does not harm the immediate neighborhood or character of the city. And the same goes for an application for the Historic District Commission. You've got to request a demolition permit, and that they're going to base those decisions on the integrity of the structure within the district and what it represents within the district and offers to the fabric of the district. So in this section, we covered who makes land use decisions and what the process is. And next, we're going to talk about how you can be involved.
Yeah, this is a little bit more of an open section, and it's a little looser. We're going to talk about just sort of the back end aspect of how planning hearings happen. Just so you understand, planning hearings their whole point is to make a process more transparent, to bring a case before the public and allow the public to weigh in. State law requires that such hearings be supported by a record that's developed at the hearing. That record is public information. So if you can't attend a public hearing, you can go to the planning office and read the file. A lot of times though, and more, a lot of that information is going online, thankfully. That record consists of public testimony and comment, as well as all of the submittals by either the applicant or anybody. What is the word I'm looking for? Protesting the application or supporting it. So next slide. So you may already know this, but a good resource is the Secretary of State website. So this website has it's a database of all municipal public bodies and their agendas. Public bodies are required to file their agendas on this website. They are not always so good about putting their minutes up there, but you can subscribe to the website. Town council, if you want to see what that looks like, and you'll get something that looks like this. You can subscribe to it and you'll get an email when the agenda has been posted. And this is all the contact information too. So it's a really good resource to kind of filter through. Next slide. When an application is ready to be reviewed by a board, a public notice goes out advertising for a public hearing. There is a particularly, there's a better way of doing this. Ideally, it has to have certain information, the location, the date, the agenda items. Some places give more detail than others. Some places tell you they'll only hear applications until a certain time, like 10 o'clock. And then at the bottom, there's always accessibility. There should always be accessibility information for people who are hearing impaired. So next slide. To distinguish between, and a lot of people get this confused, a public hearing is a special type of meeting. It's not a regular public meeting. Planning boards, zoning boards, they'll have what we call regular public meetings. It's on the calendar. The calendar's made at the beginning of the year. They may vary, they may add a few more meetings to the calendar, but a public hearing has a particular purpose for accepting public comment and testimony. So that is where, if you have a particular issue that you want to be heard on, that's the meeting you want to go to.
I think an important thing to add is that not all discussions before the planning board will have public hearings.
Right.
So an application for subdivision or land development project will have a public hearing under certain circumstances. So a minor subdivision, 5 lots or less, it is not going to have a public hearing unless they're creating a street. If they're just cutting off frontage lots, there is no public hearing as part of that process. All major subdivisions have public hearings, and all minor subdivisions with street creation have public hearings. But there's a lot of other things that planning boards do that you may not see a public hearing for. So for instance, if there is a zoning amendment before the town, the planning board is required by state law to consider that amendment and to look at it for consistency with the comprehensive plan. That entire discussion is going to happen at a regular public meeting and is not going to happen at a public hearing. So there is potentially not an opportunity for public input. It really depends on how the individual community runs their public meetings. My experience is that most planning boards will take public comment, even if it's not a public hearing, but there is no requirement for them to do that.
Yes, it's often at the discretion of the chair, and so they can decide. They kind of take the temperature of the room and they look at how much time is on, and then they make a decision about whether they will hear public comment. I would just also add that a public hearing is almost always transcribed, and so you'll usually see in a public hearing a stenographer, and nowadays they're often video. Most meetings are video recorded, I should say, but a public hearing will actually have a transcription at the end of it. Next slide. So these are a lot of little facts about public hearings. As we said, they're designed to collect public input. They are advertised in the newspaper. There's a presentation. It usually starts with the application and their series of experts presenting their development proposal. The public hearing often takes more than one meeting, and this can be for particularly controversial issues, very difficult for the municipalities, especially if they have to find like school cafeterias and bigger forums. And things often don't get resolved, and there are many people who need to be heard. So these meetings can often take 2, sometimes 3 meetings. The chairperson has the authority to run the meeting and to take any necessary measures to control the hearing. Most controversial public hearings can have police presence and other security measures. Testimony is taken at the time during the hearing. Sometimes you have to sign in, and it helps tremendously to be prepared if you are trying to give your testimony at a public hearing. Usually you want to have that well written. You want to wrap up your comments fairly concisely. You know, sometimes the board will actually put some limits on public testimony, particularly if it's repetitive. The hearing is always at a time, date certain, and any public body may ask questions at any point during the hearing, but they have to go through the chairperson. So that what I mean by that is the other planning board members may have questions, and they'll usually have the chair direct it to the applicant.
And in a public hearing, it's typically structured, as Caroline kind of alluded to, where the applicant will give a presentation and they'll put on all of their expert witnesses and all of their testimony. And the planning board will then the chair will often look to other members of the planning board and ask if they have questions or comments. And then once those have been kind of taken care of, then they will go to the public. So it is a structured process, and you know that at a public hearing, there will be a designated time to speak, but it's probably not until towards the end, after the applicant has provided all of the information and the planning board has kind of resolved their own issues and asked their own questions.
So, as Ashley just described, there is a common sequence of events, and if the chair is doing the appropriate job, this is how it unfolds. There are some variations, particularly on either development applications that are really kind of new for the planning board. That process can feel a little shakier. Sometimes the planning board will hire what we call peer review consultants, which are outside consultants who the applicant actually pays for, and they're a sort of objective third-party analysis of the development proposal. So obviously planning board members are not experts themselves. They hire experts to evaluate the application and give them feedback at the development, at the applicant's expense, usually. Yeah. So as I said before, speaking up, you want to begin, you want to be calm. You want to identify yourself. You will almost certainly be asked to give your address. You can summarize your testimony or your opinion. You can react also to the development proposal and some details about it. You want to back up that opinion. You want to reiterate your point, and then you want to get on out of there. We've seen many emotional testimonial presentations, and that doesn't work out. So organization and level heads are usually the best approach. Next slide.
I just wanted to add one thing. I've represented several citizen groups as a planning expert alongside an attorney, opposing development. And the most effective thing you can do as a citizen is to tie your comments back to those standards that the planning board has to find on. Simply saying that I walk in the woods in this property next to my house and I don't want it to be developed is not effective. And it's not anything that the planning board can use in their decision-making process. It's also not anything a zoning board can use in their decision-making process. So any concerns or questions or objections to a development should really be tied back to those basic standards that the planning board has to find on. And if you can offer them input that ties directly back to those, then it's input that they can use and consider in their decision-making process.
And on that note, which is a good point, because one of those standards that the planning board has to make its decision on is conformance to the comprehensive plan. So it does help if the community has read through their plan and if they want to make a case, they can cite it, language in the plan that says this is not furthering this plan, or this is directly opposed to this plan. I would also say any evidence, petitions are not helpful, but photographs can be helpful if you've observed specific conditions that a developer says, for example, this area never floods, and you have photos saying it does flood. That's persuasive. So, all right. You can also provide written comments, and you can send that to the board. You can usually send it to the planner, and for forwarding to the board is generally how it's done, because the planner will keep the record of the file. And you can follow it up with oral testimony, or you can just do one or the other. You're not required to do both. The public record is defined by law. All public documents must be made available to the public. There are actually a couple of particular things that are not public, like person's private, their social security number, their private information, things that are attorney-client privilege from the municipal perspective. Those things are redacted or reviewed by a town solicitor and pulled, but everything else is generally public. And the public has a right to review these documents. If we're lucky, they're on the town's website, but sometimes you'll have to actually go into the planning office and do what's called a request for Public Records Act request through the town clerk's office. Usually it's a form. Sometimes it's an online form, and the town has a certain amount of time to fulfill that request. And there's usually a charge for it, for copies and such. So anything, I'm missing anything, Ashley?
I don't think so.
Okay, next slide. So that's our part 3. We looked at meeting notices. We talked about some of the best approaches when you want to participate in a public hearing. We talked about the 2 types of meetings, public meetings and public hearings. And then we just gave a little bit of our experience on public speaking and the most effective way to conduct that. So we are open for questions.
I think we have one more piece. That's
Oh yeah, I forgot about the Newport decision making. Sorry. Do you want me to go through this? It's actually a nice summary of decision making actually for most towns, not just Newport. As we talked about earlier, there can be a TRC. There is one here. They review projects on the very, very front end. Often a TRC can include department heads, like works, police, fire, because they understand the impacts to municipal infrastructure. It can include members of the Conservation Commission or other commissions that might be relevant. And they give, like I said, they give a preliminary informal advice to the applicant about how to improve their plan. The planning board can also do this through a pre-application, but in Newport, the planning board, actually everywhere, the planning board is the stewards of the comprehensive plan. They approve subdivisions. In Newport, I guess they look at non-historic demolition, which is that is unique to Newport. They make recommendations to the city council and zoning board on zoning amendments. That's pretty typical of most places. And they talk about whether a proposal is consistent with the comp plan. The zoning board, as Ashley described too, is reviews according to the zoning ordinance. So they look at whether a particular proposal is in conformance with the use requirements that are specified in the ordinance, dimensional requirements, and such. And they also, they are the ones who grant relief from those requirements, what we call variances. Or they can hand special use permits. So certain activities and developments within the city or town require an extra layer of review, and that's the special use permit. The Historic District Commission issues the certificates of appropriateness. Their standards are outlined as well. So they have it as a zoning ordinance overlay, I believe. The Critical Area Review Committee, apparently that pertains to Ocean Drive, the Ocean Drive District, and is devoted to the preservation of natural resources. And finally, the City Council, they approve zoning amendments or new zoning standards. That goes through the City Council. All right, is that the last slide?
Caroline, I can do this one.
Good.
So we just wanted to share some of the things going on right now in Newport if you want to participate, and recent plans that have come out. So currently there's a transportation master plan going on, and I'll share the link to that process in the chat as well. But right now is totally in the middle of it, I think till the end of 2022. And there's lots of opportunities for public comment, and the website is quite good, so I'll share that. Folks obviously, I'm sure, know that DOT is in the middle of the Pell Bridge project, so the sort of community input piece of that, I think, to my knowledge at least, has sort of occurred already. But if you go to their website, they do share a lot of updates on that process, so it's a good resource. There's a Green and Complete Streets ordinance being drafted in the city as well. That's due to come to the City Council, I think, this fall. So that's, just stay tuned for that if that's interesting to you. That relates to, you know, all the uses on a public street, pedestrians, transit, as well as sort of the character of the streets. The North End Urban Plan just passed and was adopted, and that's online as well. You can check out it's a good read. That just got adopted in February. Tomorrow, there's actually a really important City Council meeting. If you're interested in the North End of town, they're going to discuss the Innovation Hub zoning amendment that's being proposed. And that is for public comment. So that starts at 6:30 tomorrow at it's a council meeting. If you go on the docket, you can review the proposed zoning amendment. And that, of course, is really important for determining the use in the new district in the North End that's being proposed. And that's sort of directly related to the new North End urban plan, of course. The other thing, if you're looking to engage, obviously the City Council is elected, but all of these, the planning board, the zoning board, and all the city commissions, there's many of them, from the Cliff Walk Commission to Tree and Open Space to all different sorts of commissions. You can apply online to be a part of that if you're interested. And of course, all of that information, the minutes and the agendas are posted online, so you can kind of stay up to date. The other thing we just wanted to mention going on as well, this isn't sort of a run by the city initiative, but the Newport Health Equity Zone has been working with Smart Growth America to develop an equitable development plan for the North End as well. And that's sort of funded privately. It's the AHES initiative, and they're working on that now, and we'll propose that to the city when it's finished as well. So we just wanted to kind of share, there's a lot going on. That hopefully there's nothing I missed, but you know, there's a lot going on in the city right now, and there's opportunity to participate for sure.
Thank you, Alex, and thank you, Caroline and Ashley, for a very comprehensive overview of the process. Just as a reminder, we will send the slides out if you want to refer back to this. It's a really helpful guide along with the video. So we have time for questions. I know we have two that are in the Q&A, and my associate Jillian is going to manage this process. But I also wanted to invite folks, if you want to raise your hand to ask a more in-depth question or to make a comment, you can do that, and Jillian can actually bring you into the room so we can hear you and see you. So feel free to raise your hand if you'd like to do that. But now I'll turn it over to Jillian.
Well, we're going to start with the two questions that are in the chat already, or in the Q&A, I should say. Going back to the public hearing and having questions about the first one about expert testimony evidence versus resident testimony, and can a board rely on resident testimony to overcome expert testimony?
I can answer that, and Caroline, please jump in. there's two types of expert testimony. There's the expert testimony that the applicant is going to bring to the table, and they're going to present a series of experts, from transportation to environmental experts. But applicants have also, been able to organize themselves and provide their own expert testimony. And so expert testimony is typically given more weight than, say, a resident testimony. But if resident testimony can speak to, like Caroline and I described, back to the standards that they have to adhere to, or if you can produce pictures, if you can refute some expert testimony with actual photographs of an area that does flood, or that does have, major traffic issues that the traffic expert is saying don't happen or are not an issue, they're definitely relevant. They're typically not given the same weight. So they'll listen to both, and they'll weigh those slightly differently. But if you could, like I said, if you can structure it, if you can keep it concise, if you can kind of take the emotion out of it, they're much more able to listen to that resident testimony and weigh it more heavily, than they would if it's just I don't like this in my neighborhood.
I'll just tag on to that, though. The board is supposed to vet who is considered an expert.
That's
So,
true.
and they often forget. So either, and staff may try and prompt them. If that doesn't happen, somebody from the public could say, this person is calling themselves an expert. I'd like to know what their credentials are. Because I've seen on some very politically charged issues, people standing up and calling themselves scientists. And I'm sitting there on my phone looking at their credentials, and they got a certificate in political science, like, years ago. That should not be allowed. And so, but chairs often forget because they don't do this all the time. So the public has to be a little vigilant. Everybody's fallible in these processes. So, you can patiently and stand up and say, I'd really like to hear this person's credentials.
So there's another question talking about standing in a public hearing, and when do residents have standing to testify and when do they not?
There is no such thing as standing at a public hearing. You can be from China and you can show up in Newport and testify at a public hearing. So the public is the public. It doesn't matter if you live next door or you live, 100 miles away. Now, will they weigh your testimony differently? Potentially. If you're a resident versus a non-resident, or a seasonal resident versus a full-time resident, which is why often at a public hearing, you'll hear people are asked to provide an address. But there is no prohibition against anyone speaking at a public hearing.
All right, there's another question. What is the effect of legal challenges to changes in zoning? Is that a vulnerability? How is this possibility dealt with?
I'm assuming the question is if the town council adopts a zoning amendment, what if there's a legal challenge to that adoption to a zoning amendment? And it is a vulnerability, and it can be appealed, or and somebody from the community that has standing could come in and potentially oppose that and challenge it legally. The vulnerability really goes back to the comprehensive plan. I mean, that is the basic fundamental finding that has to be made, is if you change the zoning ordinance in some way, or you change a district in some way, is it consistent with the comprehensive plan? And if the community is very careful and the town is very careful in how they structure the zoning amendment and how they find on that approval, it should be relatively solid, but it doesn't mean that it cannot be challenged.
I would just add too that keeping in mind that land use planning operates at multiple governmental levels. So we're talking today about the municipal level, but there's state law, there's federal law that relates to not just land use planning, but for example, disabilities or other aspects of people's lives that can be found in development. So the legal challenge may not even, it may deal with something, some other disenfranchisement that somebody has identified. But it's, as Ashley said, it is definitely a vulnerability. It definitely puts the development in that zone in some level of flux.
A change to a zoning ordinance is a very structured process, and it's laid out in state law. And I've seen challenges just based on the structure, not even the content. So somebody may have an issue with the content of the zoning amendment, but they found a flaw in the advertising or in the process in some way, and that can derail the zoning amendment process completely, and cause it to have to start over. And I've seen that used as a tactic, making the argument that one of the names on the abutters list was wrong, and that can stop the process. If it's a legitimate claim, that can hold things up or stop the process.
All right, are there any more questions from our attendees? Anyone want to type a question in the Q&A or raise your hand if you would like to speak to ask your question? Let's see. Oh, is loss of property value a meaningful reason for suit?
I'm not an attorney, so I'll answer carefully in just saying that it wouldn't be, in my experience, it would not be the sole reason for something like that. You couldn't just appeal it on that basis alone. If there are other issues, bigger issues, again, relating back to consistency with the comprehensive plan or if there are environmental issues, those are all grounds for an appeal or a denial. But I don't believe you'd have much success just based on a loss of property value. It would have to be fairly substantial, I think.
I was gonna say it'd have to be a total loss.
Yeah. I mean, if for some reason whatever development was approved, completely negated the use of your property, then yeah, you'd have something there. But just because you might get $10,000 less when you sell your house because you now have, maybe a solar array next to you, that's probably not going to go very far as a sole issue.
All right, everyone, we have like 5 more minutes for questions. So please speak up, feel free, type them in the Q&A. Raise your hand. Oh, we want more. Okay, what is the abutter range for commercial properties on main streets?
So I believe the minimum zoning is like 200, but the community can increase that. I know, like, for instance, in Exeter, before the planning board, it's 1,000 feet, which is a huge abutters list. But typically the standard that you're going to see the most is 200 feet, unless the community takes action to increase that area.
All right. Well, I am not seeing any more questions. Oh, wait, one more. How can a city use eminent domain to help establish building community benefit, such as a bike path for connectivity? So
we don't use eminent domain very much up here. And I went to school in North Carolina and I worked there, they actually use it quite a bit down there. There's a huge process, and a lot of it is tied to how your project is funded or whatever it is you're doing. It's a political issue, I would say, as much as anything, because I don't know too many politicians that are going to want to take property, particularly for something like a bike path. They'll take it for things that are necessary, but not necessarily for some things that are optional. Not to say it can't be done, but it's just politically charged issue. The process is long, and it involves appraising the property. There's a certain prescribed process for doing that. And there has to be a mechanism for executing the eminent domain process. And if you're buying out property, depending on your funding sources, if you have to relocate tenants, that sort of thing, it's a very hairy process, and that's probably why it's not utilized very much up here.
I think the most recent example I can give you of at least considering eminent domain is the Metacomet Golf Course in East Providence. The city was petitioned basically to take it for eminent domain, and after much consideration and advice, came to the conclusion that that just was not gonna bode well for them. So if you're interested in that story, it might be a good example of why it's not getting used.
Now, go back into the questions on the lawsuit. Eminent domain will almost assuredly bring forth
A lawsuit.
All right, one last quick clarifying question. Can a resident be considered an expert, for example, someone who is a civil engineer or professional builder?
Absolutely. Yes. Yeah, if you have expert knowledge in the field, if you're a land surveyor and you live in town and this is going on, or you're a wetlands biologist, you're not only a resident that experiences, the community, you're also now an expert in a particular field. And my advice would be, if you're going to take that approach, present your qualifications, as Caroline mentioned, whether it be through submitting a resume or a letter, explaining what your experience is, because your testimony will likely be given more weight by the planning or zoning board if you're not only a resident, but you're also an expert in a particular field.
All right. Oh, we're just about ready to wrap up. One last one came just, can you give an example of what does no harm to the character in demolition permits looks like?
I don't have any experience with that. Caroline, you have a thought?
I have not really heard that phrase. I worked in preservation quite a bit, but what I'm assuming that they're saying is, let's say you have a historic district, but there's a structure there that is not contributing to the character of the district. Maybe it's a later construction, maybe it's just something that's not contributing. Then the demolition of that structure, I think, would be fitting this description. I'm not, but I'm just saying that I'm kind of winging it because I'm really not familiar with that particular phrase.
Another example I could think of maybe is, even if it is a historic structure, if it's in such disrepair that it can't be renovated, then it's not contributing, and therefore it would be better to be demolished and replaced with a habitable structure.
Yeah, well, then we're getting into those preservation issues of demolition by neglect. And
True.
I don't want to open that can, but it's
That
there.
might be in the 102 version.
Yeah.
That more advanced question. And we're also actually at time. So I'm going to close our Q&A and turn it back over to Alex and John to take us home and say thank you to our panelists.
I'll jump in and I'll just say, I know we are closing in, but thank you all for attending. Thanks to our expert presenters and to our partners at the Aquidneck Land Trust, and finally to our funders, the Van Buren Charitable Foundation. Just a quick reminder that there is the survey. It's not going to take a lot of time, but it will be very useful to us It'll be on your screen when you close. And then the final reminder is that the Portsmouth presentation will be on September 29th if you want to pass that on to your friends in Portsmouth. And then do come back on October 20th for the island-wide next steps workshop. And then we'll get into much more detail and things that are happening on the ground at that one. So Alex?
I don't have anything to add other than thank you everyone for coming.
Terrific. Thank you. Have a good night, everybody.